Hello, everyone. Welcome to this Leap to Capability learning session. In this session, we'll be looking at European Union General Data Protection Regulation, or in short, we can just simply refer it as GDPR. So in this session, we'll look at what is this all about and what basic preparation that any organization need to take care to comply to this law. Firstly, GDPR is a European Union law, which was effective from May 2018. It essentially regulates the collection and the use of personal data. We'll see what do we mean by personal data in a while. And the most important point is it gives individuals, which is nothing but customers, a right to access their data, which is collected by any organization. So say, for example, a bank collects the data from its customers to open a bank account or to disperse a loan. Now, we as a customer, after a few years, we may not know what data we have shared with them. And in this current law of GDPR, it gives a right for any customer to ask the organization, a bank in this example, seeking what information they have about us. And they're obligated to share all the information they're holding. And when we say any organization, in the context of GDPR, it is relevant to only those organizations who have business presence in European Union. And when we say business presence in terms of either they have their customers or vendors or employees. If any one of these three categories of people are present in European Union, then that organization has to comply with the GDPR law. So when you look at the structure of the GDPR, there are 11 chapters and there are 99 articles in total. And these are those 11 chapters, which essentially outlines in detail various aspects of the law that the organization need to take care of. Now, there are several terms that are used in this law. So a very good understanding of these terms is important so that it's interpreted in the right way, and accordingly formulation of your policies and procedures will be appropriate. So in this session, since it's an overview session, I'll be talking 8 terms which I personally feel are important for anyone to know at the beginning. And as we go along, you can go through the document with regards to the other terms. To start with personal data. Now, what do we mean personal data? Before that, let me tell you in this document, because it's a law, the kind of language that is used in the document is like a typical legal language. So, the words are a bit complicated and long sentences. So I try to simplify them here for ease of understanding. But when you read it, you got to be cautious in interpreting it the right way. So here, these are not the exact words as you would find in the document. I've simplified it for a better understanding. So when we say personal data, any data that points to an individual, okay, is a personal data. Let's say email ID or any national identification number. And so on. There are many biometric data that we collect about people. So any data that you can attribute to an individual specifically becomes a personal data, including my address, now mobile number. But let's say the city of residence may not be a personal data because there are millions of people who reside in a city. My date of birth will become a personal data. But having said that, date of birth alone may not be, because there could be many people who are born on that particular day. So date of birth along with something else as a combination could become personal data. So first and foremost thing is a clear understanding of what is a personal data that you as an organization are collecting, because this is a core of this whole law, right? Because it's all about protecting personal data of the people. Processing. When we say processing, once the organization collects the data, what is the activity that it is performing? Like if you take an example of a bank, now once the bank collects an application form from the customer, let's say to disburse a loan, then there's a back-end activity that happens, which we as customers don't see that, based on which final conclusion of a loan being disbursed to a customer is made. Now, what are those activities that are performed? So we are not looking at a whole range of business activities. When we say processing, it is in the context of the personal data use. So as a business, they would be performing many more activities, but here we're looking at from a personal data standpoint or a GDPR standpoint. Filing system, whether it is a hard copy application forms you collect or digital, nowadays more and more companies are moving to digital media, whatever may be the media. So how do you store the data is very, very important, simply because the quickness of retrieval of that information is critical, right? When a customer asks for a certain data or any statutory body asks for any data, how quickly are we able to retrieve that data becomes important, and that is dependent on the filing system. And then controller is the organization who is deciding what data to collect from the customers, vendors, or employees. So the organization decides what data to collect, why they need to collect, and what is the processing that they need to perform, that we saw in the previous slide. So essentially, controller is that decision maker. And processor is someone who is performing the processing activity. In cases where the same organization performs the activity, both controller and processor will be the same organization. But if you look at within the organization, function A could be a controller playing the role of a controller, and function B could be playing the role of a processor. And if you go one step further, if you have outsourced a particular business activity, then that outsourced organization will become a processor. However, the accountability still sits with the controller. Recipient is anyone who receives the personal data. More often than not, it could be the customer themselves who are seeking for that clarity. And in other cases, it will be any statutory body or any legal body which is asking for that personal data for some purpose, for a specific purpose. Third party, as I mentioned earlier, if you have outsourced any processing activity to another organization, then they are referred as a third party. Consent. Now, this is a very key element and a differentiator in this law, which never existed till this time, which is whenever an organization is collecting data from any customer, you need to take their consent, in the sense that we are collecting so-and-so data from you, and this data will be used for ABCD activities. So all of that need to be spelled out very clearly. And in the GDPR law document, it has been very clearly mentioned that it cannot be hidden in the whole range of terms and conditions. More often than not, some of these terms and conditions that you see in some application forms are not even legible, such a small font. So it's very clearly mentioned, and that's what I have highlighted here. This has to be provided by a clear statement of affirmation. So there has to be a separate signature that has to be taken on where we are seeking the consent of the customer. And if it is a digital, we are talking of the electronic media in terms of, you say, I accept, things like that. So taking consent of a customer is the crux of this whole law. The lack of that process here could put the organization into trouble. And just to go one step further, let's say today I've collected the data for one particular activity. Again, I'll take the same bank example. I've collected the data from customer for, let's say, loan processing. Tomorrow, this bank has diversified into some other product. Let's say automobile loan, vehicle loan. Now, I cannot make use of the same data which I've collected for a home loan to do my marketing activities and reach out to the customers for a vehicle loan. You have to take their consent again that, yes, can I reach out to you? Can I approach you for cross-selling this product? So it is that clearly specified in the law. So those are some of the key terms that I spoke about. Now let's look at the important stages of any data lifecycle. First of all, what is a data subject, or who is a data subject? Data subject are those from whom you are collecting the data. As I mentioned at the beginning, it can be customers, business partners who are typically vendors, and employees. So the first step is, of course, collection of the data. It can be hard copy or digital. And storing of the data. How do you store? If it is a hard copy, your filing cabinets, box files, flat files, in whichever way you store. If it is digital media, how are they stored? Where are the servers? Or is it a cloud-based? All of that. So that clarity you need to have. And then the processing. This is the key part. Here we are just illustrating at a high level what are those key processing steps you perform on this personal data. And lastly, disposition. More often than not, it has been observed that some organizations don't pay much attention to this because that may not be a point of concern immediately. But having said that, every organization need to decide or define what is the retention period for every record or every document. That's very, very important. You cannot say, I'll preserve this document or this record for lifetime. That's not going to work practically. So some cases, there will be laws that you have to abide by. For example, if you talk vendor invoices, every organization which receives invoices from its vendors need to retain for a certain period of time. It varies from country to country. Typically, you hear 7 years as one time frame. Now, on top of it, you may be more conservative and say 10 years, which is fine. But then you got to be very clear, do you have enough space to store those records, either physical space or digital space? So all of that need to be thought through. And once that retention period is crossed, let's say 10 years, you have an invoice which is beyond 10 years. So what are you going to do? You can't simply tear and put in a dustbin, or you can't just simply delete them. There is a way to either shred the document or digitally erase them permanently so that it cannot be accessed by other methods. So a very thorough review of this disposition process need to be looked at. What is data breach? This is the whole crux of this. If you do not have data breach, life goes all well. There is no problem from the law standpoint. The moment there's a data breach, the trouble starts. So essentially, if any part of this data is accessed by someone, when I say someone, either individual or a function or an organization who is not supposed to have access to it, right? And that is as critical as that. Let's say the marketing and sales team collect the customer data, and there is some other team, let's say an admin team. They have no business to access customer data. But if for some reason or somehow if a person working in admin department gets access to it, now that's a data breach. Though it could be within the organization, it's still a data breach. But if it goes outside of the organization, of course, the consequences are even more serious. Now, what can happen? One, first and foremost, it has to be complained to a regulatory agency. And naturally, there'll be an investigation that will follow with financial penalties, depending on the seriousness of the data breach. And of course, needless to say, nowadays, at a drop of a hat, you have media, prying on everything and everyone. That could lead to loss of customers because you lost credibility and hence loss of revenue, reputation damage. Employees could be dissatisfied if it pertains to employee data, or even if it's customer data. They'll think, okay, what kind of organization and systems do we have? And lastly, in some cases, even vendors may not feel comfortable doing business. So I'm not saying all of this will happen, but some or most of it could happen depending on the type of data breach. And what are the consequences from a law standpoint? In the event of a personal data breach, first and foremost, the controller should inform the supervisory authority. By the way, that's another term, though I didn't explain here. It essentially means there is a governing body in the GDPR law who need to be notified, right? And within 72 hours of being aware of it. Now, this can get a little subjective, but with enough, trail of information and data, we can prove when you got to know, right? Everything is through emails and many other media, so you cannot bluff on that. So from the time any function in the organization gets to know that there has been a data breach, within 72 hours, you need to inform the supervisory authority, who is nothing but a relevant authority in the government of European Union. And if there's a delay, you better have a good reasons for it. Otherwise, there's going to be a penalties even for that delay of information. And non-compliance could result up to a maximum of 4% of the global revenue of that organization, or 20 million pounds. I mean, this is the maximum limit I'm talking about as defined in the law. It can be anywhere within that, and this will be decided by the investigating agency officials. And also a company can be fined up to 2% of global revenue for not having their records in order. We spoke about filing system as one of the term. As a part of the investigation, if they find that there is no enough systems and processes in place to prevent such a data breach, then even that would lead to a problem, right? So there are two parts here. One, you have a well-defined system, but something happened, either hacker or somebody with wrong intentions in the organization, some employee has leaked the data. So that's one part of it. Then you need to put more controls and checks and balances. The second part is, yes, somebody hacked your systems, or there's some employee has leaked the data, but on top of it, you don't have enough adequate systems in place to have checks and balances. So then that would double up your penalties. Now, one common question we always get is, what is the difference between a GDPR and ISO 27001 standard? I'm sure most of you know this. There is an ISO 27001 standard, which is in principle similar to what GDPR is doing, right? So let's look at a very high level what the differences are. Firstly, GDPR, it is a law, right? We need to understand a law is different to a standard. ISO is a standard. Now, when you say a law, you have no choice. You've got to abide by it. Anyone who does business in European Union, you have no choice. And if you do not comply to that, then you have penalties. Hence, as I said, there is no choice, it is mandatory. So as long as there is no data breach, life goes fine, everything is nice and good. And if there's a non-compliance, yes, it will attract financial penalty and other, reputational damage, etc. When it comes to ISO 27001, for that matter, any ISO standard, it is a standard. And this 27001 is referred as Information Security Management System, in short, ISMS. In principle, as I said, conceptually, if an organization is ISO 27001 certified, to a large extent, you can be confident that you could be complying to GDPR. There are just few minor things you need to tweak. And having an ISO certification is an optional, right? It is not mandatory that I have to have an ISO 27001 certificate. Why do companies go for it? So that it builds confidence in the customers and other stakeholders that this organization has been audited by some third party and all their policies and procedures are in place in compliance to the ISO standard. So it just gives that confidence, because nobody can come and audit any organization systems. Right? Nobody has a time and nobody can't even do that practically. But the moment you have an ISO certificate, it gives that credibility and confidence that yes, they have some checks and balances in place. And as I said, certification, it is a choice. It's not mandatory. You may not have an ISO 27001 certification, but your processes and procedures could be absolutely rock solid. That's possible. But the question is, how will you authenticate that? Who's going to say that? We ourselves saying that, oh, my systems and procedures are great. That's no big deal, anyone will say. So how do you manage that perception is the difference. And yes, when it comes to ISO certification, you got to get certified through some authorized agencies who are, accredited by ISO organization. And then you have to go through this process of annual renewal audits and, things like that. But anyway, those are all administrative points. Essentially, if you see GDPR is a law, you have to comply to that. There is no choice. ISO standard, it is a standard. It will increase your, credibility in the eyes of the customers, but it is a choice. It's not mandatory. Now, what is the relevance of data privacy? I mean, needless to say, irrespective of the type of industry, every organization will be capturing data from its customers, vendors, and employees. And more it's increasing in the electronic form. The moment you say electronic form, the ability to get hacked or data leakage is high. So you need to have much more stronger technology-based checks and balances. And you cannot say that this is only relevant to, conventional thinking was, oh, it's very critical for banks and other financial industries. But that's not the case anymore now. Every organization do collect data from their customers, so that all of that becomes personal data. So the key question here is, how secure is the data that we are collecting and processing? That is the whole underlying point here. If we are able to answer this question to ourselves first, forget anybody else outside. If you are able to answer this question to ourselves confidently, then that's it. You cross the hurdle in a very positive and confident way. So what are the next steps at a very high level? Okay. Once you get an awareness about GDPR, and once you have a team formed who will be looking at this GDPR compliance in your organization, what are some of the key steps? I'm just illustrating at a very, very high level. First, you identify those functions or processes that directly interact with the data subjects, be it customers, vendors, or employees. Customers could be your sales marketing team. When you say vendors, your procurement and supplier management team. Employees are typically HR and recruitment team. So these, and I'm sure there'll be many other functions. These are the functions who directly interact with any of these data subjects. So first you identify who they are in your organization. Then for each of these activity, you map out the end-to-end process. And let me clarify, the objective of this is not to identify what are the inefficiencies in the process, what are the bottlenecks from a productivity standpoint. That's not the intent. That's a totally different exercise. Here, the objective of mapping out the end-to-end process is to purely look at it from a data compliance standpoint, right? How are we collecting the data, storing, etc., all of that. So it's only from that standpoint we are doing this activity, not in the generic business sense of, productivity, efficiency gain. So that's a different activity. And once you do that, you will have a list of those functions or people who have access to the data, right? We need to be very, very clear who are those people or who are those functions who have access to these various forms of data and why. So that business justification is important. Some of it may seem obvious, but still document it as much as you can. And then you, based on this, that is when your policies and procedures will come into picture so that you comply to the GDPR. And lastly, you also need to perform a risk assessment. That is a requirement as a part of GDPR. Similarly, as a part of ISO 27001, you have to perform a risk assessment. So as I said earlier, if you are ISO 27001 certified, or even if you have done compliance to ISO 27001 in principle, you may not have a certificate, that will put you in a good, strong position to comply to GDPR. So a performance of this risk assessment and identifying mitigation actions is very, very important. And this is a very dynamic document. So don't think that you have done it once, it's done. So it has to be reviewed periodically. Now, this is very subjective, whether you do monthly or quarterly, that's your decision, but at least quarterly for sure. Monthly may be too early. At least a quarterly review of the risk assessment is well appreciated. So just to summarize, it's all about capturing only the necessary information and how do you store the data, and ensuring this access to this data is to those authorized people or authorized functions only. And performing a very thorough risk assessment is critical. Lastly, if there are data breaches, and there could be, anything can happen, the key point is report yourself immediately to the supervising authority. Believe me, when an organization themselves reports data breach rather than a customer reporting, there's a difference, right? So that shows that you are being on the front foot, you're taking charge of the situation. So it's all about securing the data. So with this, I conclude this topic on GDPR. And before I end this session, few reminders. Firstly, I would like to end with my quote. Always have the mindset of a student, because this is what is important to keep your learning process active, whatever topic it can be, whatever subject it can be. Do subscribe to this YouTube channel for more such learning session videos, and share your feedback. If you want to know any more specific topics on anything else, do share, and we'll get such similar sessions recorded by the relevant experts from the industry. Thank you.